It's the midweek plenary session in the Senate, and the federal lawmakers have just commenced the process of amending the 2022 Electoral Act. The Senate has taken this step 2 days after the Federal High Court in Abuja had restrained the National Assembly from making any amendment to the Act. This move causes mixed reaction in the Senate. After the Senate leader, Senator Yahya Abdullahi, gave the lead debate for the second reading of the bill, senators kicked against it.
Anywhere else in the world where democracy is properly practiced, like in Nigeria, we don't need to be told that if we want to run for office and we are appointed into an office, that we have to resign. That is a sine qua non that we don't even need to debate. Yet, here we are today in Nigeria, and people think that they can sit in an office and contest an election.
Amidst opposition, the Deputy Senate President argues for the amendment to be considered.
That no political party shall seek to disqualify anybody by importing into the process a provision for qualification or disqualification not otherwise provided for in the Constitution. It is there at the beginning. I believe that's section 84, section 84(2). Mr. President, Mr. President, I therefore rise to support the motion as moved by the Senate leader, that we allow this very bill to go to second reading.
And when the President of the Senate puts the bill to vote,
that this bill be now read a second time, say aye. Those against say nay. No, I'm not putting the question again because I put the question, there was an aye and there were nays, and I said the nays had it.
This vote may have effectively put an end to President Buhari's plan to review Section 84, subsection 12 of the Act, as the House of Representatives is yet to consider the bill.
Well, that was what transpired on the floor of the Senate yesterday. Do not forget that the Senate initially had said they were going to ignore a court order which was trying to prevent them from considering that particular section. They said that the three arms of government are separate and different in their functions, and that the judiciary could not interfere in their primary assignment of lawmaking. But that was what happened when they tried to amend it on the floor of the Senate yesterday. It was roundly rejected. Do not forget again that the president, while putting pen to paper, had asked members of the National Assembly, said, look, I'm going to sign this, but he thinks that Section 84, subsection 12 particularly, is a defect on the newly signed Electoral Act, and was asking that it be amended. There have been mixed reactions to that, but you did see that he sent it back, and that was what came out of it. We have a few guests to help us, dissect what went down on the floor, if they also thought that the legislators were in their right. Were in the right in terms of the arguments that went on the floor. They have no power over the votes. What it is what it is. But this morning, we have with us Mr. Dauda Arioshu, who is an associate professor in the Faculty of Law, University of Ilorin. He joins us via Zoom from Ilorin in Kwara State. Sir, you're welcome to the program.
Thank you very much.
And I also have here in our studios with us Mr. Silas Onu, who is a legal practitioner, and he is also a member of the People's Democratic Party. You're welcome to Sunrise Daily this morning.
Thank you, Margaret.
I'm going to start with you, because I was here, and I still remember the time when the president signed that Electoral Act. I think it was it 21 minutes past, or 25 minutes, it was on the 25th of February, and it was at exactly 25 minutes past noon when he put pen to paper. were monitoring what was going on. No. And the president read a fine speech, praising and lauding this electoral act, but he minced no words when it came to Section 84. He called it a fundamental flaw because he said it negated the Constitution, was not in tandem with the Constitution as it was discriminatory. I do not know what you made of it, but when he signed it, it would seem that there was a gentlemanly agreement because the president himself had come under intense and immense pressure to sign. Would remind us that, Mr. President, you said in January that if we amended this part, you will put pen to paper, the initial part which had caused problems, direct and indirect primaries. And they put all the parts he asked for. So it looked like, I'm going to sign this, but this is my observation, and I expect that you people will do the right thing. This is what has come out of it now. Do you think that this is going to break trust between the executive and the legislature?
Well, thank you very much, Mark. I think that the legislature have done their job. The president ought to simply do his job on the 25th of February and not delve into judicial functions. He had attempted to interpret Section 84.12 by saying that it infringed on the right of those political appointees, which is improper. If you don't want to sign a piece of legislation, don't sign it. If you want to sign it, don't start giving conditions. It is not in the place of the legislator to delete sections that have been passed. They can amend a law that have been duly passed, but they cannot start deleting. Now, the court can delete by declaring sections null and void, being in contradiction or contravention to the Constitution. So if you feel your rights has been infringed by the provision of Section 84.12, the proper thing to do is to approach the Federal High Court and then show them that that provision is inconsistent with one of your rights that is already enshrined in the Constitution. You must show that that right protects your right to hold political office.
But this is not the first time we've seen it. I mean, this is not the, even in this administration, it's not the first time we've seen it. With the petroleum industry bill,
yes,
when the president was going to put pen to paper, there were certain areas that he was uncomfortable with. There were certain areas he still thought needed amending. And in fact, when people were talking about his sincerity or otherwise in signing the electoral act, let's not forget that it's been before him at least 5 times or so before he eventually signed it the 6th time he came before him. People cited examples of how the PIB went to him, he signed, and then asked for an amendment, which was granted. So it was not new that this was happening, and it would seem that it was a gentleman's agreement to at least get this process going.
You see, the Electoral Act is much more, for me, much more special and much more important than the PIB. PIB is sector-specific, right? But the Electoral Act affects everybody. And there are more interests in the Electoral Act than there are for the petroleum industry bill. And because he did it with the petroleum industry bill and the National Assembly played along, doesn't make it right. It doesn't make it right. You cannot be asking the National Assembly to delete a provision. What they did yesterday was not an attempt to delete. Was an attempt to amend the law they just made. They have not even been tested anywhere. You just made a law, allow it to be tested. Let's see whether it is practicable first. If it is not practicable and it creates problem, then you now have a reason for amending it. The only reason they have for amending this is that the president said it should be amended. The president is just a person. The law is not for the president or for his appointees. The law is for all of Nigerians. So there are people at a state level that this law will impact on. There are people at the federal level that it will impact on. Any of them that feel the law offends their rights can approach the Federal High Court. And if the court agree with them, that law will be declared, that section will be declared null and void. It will become inapplicable. So there is no need for the controversy the president sparked on the day he signed the Electoral Act into law. There is no need, absolutely. In fact, he has helped to advertise the need to oppose his request. Because the moment he made that statement, someone like me started a campaign against the removal of the section. I made a poster and published, said there is no right to hold in public office. Nobody has a right to be appointed into public office. It's a privilege. So if you are appointed and you want to serve the people, serve the people. If you want to now join partisan politics, resign when you want to contest. The law didn't use the word you must resign, but by implication, you cannot be voted for and you cannot vote in party congresses or convention. Meaning if you want to vote or you want to be voted for, you simply have to relinquish that public office. Now, it is for people who are appointed. It doesn't affect elected officials. It is only people who are appointed. So you don't expect the president, his vice governor, his deputy, members of the National Assembly to be resigning whenever election is about to be conducted and they want to participate in primaries. Those concerned or those affected are people like ministers, board members, because there's no clear definition of political appointees. But if you go to the dictionary, you would see it. It is someone who was not elected, who has been appointed. Even board members are all political appointees.
From what you're saying, it certainly has far-reaching implications. So let me ask our guest who joined us via Zoom, Mr. Ariosho, what you make of this. This certainly has far-reaching implications, and the inability of the Senate first, because we don't even know, I don't think it's been considered on the floor of the House. It has not even been announced on the floor of the House. Talk more, I don't think it's gone up for first reading, that's what I mean. But this is what has happened at the first reading of this bill on the floor of the Senate. What is your reading first when the president raised his own objections, and now that the lawmakers have voted against it? What do you read from this?
Thank you very much. You see, there is no law that is 100% perfect, and once a law has been passed, and the president has given his assent to a particular law bill passed by the National Assembly, at least let the law be tested first. If the law has not been tested, and you are talking about say deleting some parts of the law, let the law be tested first. And I think even if there is defect in the law, there are procedures for everything. The court is there. Approach the court for proper thing to be done. You can ask the court to void some part of the law. You can ask the court to strike down some portions or provisions of the law. But this law itself has not been tested. Let us test this law and see how far we go about it. But unfortunately, the National Assembly that has gone through this rigor of passing this law is now saying that you want to delete some part of the law. No, let the law be tested first. And at any rate, if all what you want is that some portions of the law are not favorable to you, the best thing for you to do is to approach the court. You have not approached the court. You are doing what the judiciary is supposed to do. You cannot do it on your own. You can't do it on your own. But the most important thing is that proper thing must be done. Proper procedure must be followed. If proper procedure is not followed, the end result is that you still have to go back to the court. Because some part of the National Assembly will still feel that, no, what you have done is wrong. Let us still approach the court for the court to set aside whatever decision you must have made. So why can't we just wait first, let the law be tested? If the law is not good for you or you feel that it's not in your favor, yes, you approach the court to do the needful. It's not just a matter of you have passed this law and some part of it is not favorable to you after the president has already given his assent to the law. So my own view is that we should wait and test this law first. Let us see how it will work. And if you feel that you are not comfortable with it, approach the court. That's simple and straightforward. Thank you.
Let me follow up on that, and perhaps this is for both of you, but I'll start with Mr. Ariosu, really, because, I mean, I think both of you seem to agree that this is not the appropriate way to go about it, but it begs the question. Even this electoral act that we have now, at some point it was an electoral act amendment bill. I mean, the amendment process was not first done through going to court and then testing it and then coming to amend it. You know, this was presented on the floor of the House, you know, by lawmakers, as it were. And there are different ways to amend laws. There are executive bills, individual bills, and all of that. So is it unconstitutional for the president, which in this case will not be an executive bill, to ask for an amendment? Because, I mean, except if I'm wrong, I've looked around, and that is allowed as well.
Yeah, thank you very much. Well, of course, the president himself can ask for amendment of the law, and the proper procedure must be followed before the law can be amended. But what I am saying is that this is a law that has just been, not been passed. The next general election is coming up next year. Let this law be tested first. Because at the end of the day, if you want to amend the law when it has not been tested, at the end of the day, what you want to amend may eventually turn out to be that you are not supposed to amend that law. Because, like I said from the beginning, that there is no law that is perfect. There is no law. All we have to do is to make it work. Make it work, unless
But
the law
what the president did,
absolutely bad.
So what the president did, let's just be clear, is it unconstitutional or not?
No, of course, it's constitutional. Of course, he can do that.
So his rights to ask for an amendment then?
Yes, he can ask for an amendment. He can ask for it.
I just wanted to clear that out. So this is just more of a perspective thing, saying that, it's not right. It's not a legal or constitutional issue that you're pointing out here. And by the way, that's the provision that is being talked about. But we'll get into that one. But just to get the definition, because I see Mr. Onu has tried to define who a political appointee is. But really, is there a clear-cut definition? Because the Electoral Act does not define who a political appointee is, as it were. And this is for Mr. Riosu before I come to Mr. Onu. I just want to get your opinion. So when you bring political and appointee together, is an appointment to a political position, as it were? And some will tell you even electing a governor is some sort of appointment. So do you think there will be issues regarding who a political appointee is or who a political appointee is not based on this new law? Just quickly before I take it to Abuja now.
Yes, thank you very much. Well, political appointees, there will be a need to distinguish between ordinary political appointees and when you have people elected to public offices. Yes, on the issue of political appointees, once you are appointed to a political office, it behoves on you to uphold the Constitution and all laws of the Federation. And of course, if you are a political appointee and you want to contest for an election, I think it's a very good law when you first resign your appointment before you contest for another political position. And I think I know there are provisions in the Constitution that when you want to contest for a particular post, you have to resign your appointment before you. Although I think in the past there are judicial authorities to the effect that talking about right to freedom of association, that you do not have to resign your appointment if you are a political appointee and you want to contest for an election. But I think it's a good law for a political appointee to first resign his appointment before venturing into another political position. So you can't hold a particular political appointment and you still want to apply for another political appointment, probably which is higher in degree than the one you are already holding. So resign from that one and contest for the other you want to contest for.
Well, that raises another question, Mr. Ryoshi. Let me ask Mr. Ono this question. I mean, you've tried to define, as my colleague has said, but then if you look at the provision again, as we saw it on the screen earlier, it says no political appointee at any level shall be voting delegate or be voted for at the convention or congress of any political party for the purpose of the nomination of candidates for any election. This provision, Mr. Ono, does not give a timeline when it will be effective. So it would seem like there is some vagueness of sorts in that regard as well. When it comes to operationalizing it, at what point then does this politician who is an appointee and is aspiring to be elected into office have to resign his office or leave the current appointment to go, vie for an elective post?
Thank you very much. There are three issues, but I will start from the last one now. I don't think there is vagueness regarding the timeline for such a person to resign, in that different political parties have different timetable for their activities. So once it is clear that political appointees cannot vote by this provision, they cannot vote, they can only be voted for, right? Now, if by party constitution, they are given the right to vote in a congress or convention in which they are participating as aspirants, they can vote. Now, regarding when they can quit office, since there is no timeline, you can quit office a day to the scheduled Congress or convention. You can quit office a day to it. What is more important is that on the day the Congress is holding, you no longer are holding that public office as an appointee on that day. So you must leave office before that day. It can be a day before it, it can be a month before it, it can be 3 months before it. The person who has that interest will have to decide for himself or herself, should I resign a day before? Will that allow me participate fully in the processes leading up to the Congress or convention? Because if you don't resign, I do not know if you can pick up nomination form as a candidate and begin to campaign. But the operational word in this section is that you will not be voting and you will not be voted for in the Congress or convention.
Okay,
I do not think the section forbids you from campaigning.
Well, you have already begun, Mr. Onu.
Nomination form.
Mr. Onu, you have already begun to look at some of the issues that may arise. I mean, you've just asked the question now. When does he pick up? Just a second. When does he pick up the nomination form? Is it before or after, he has left office? That's one issue. You may also want to speak to this. In the event that, okay, he goes in for this convention and he does not get the desired reason for which he resigned, what happens? Does he go back to the appointment, or is he reappointed, or what happens?
The appointment is not a birthright. The office was not created with his name on it. Once he resigns, he's out. If the president who appointed him or the governor who appointed him finds him fit to return, they can bring him back. And you see, there is no law that cannot be circumvented. What this law requires is that you leave office before, on the Congress day, the day that election will be held. That is the day your right is determined to vote or not to vote, on that day. So you can resign a day before the Congress. If you lose in the Congress, the president may reappoint you. That is his prerogative. The governor may reappoint you. That is his prerogative. And that takes us to the definition of who a political appointee is. My definition, which is straightforward, is that a political appointee is anybody who is appointed by an elected officer. An elected officer being the president and his vice, the governor and his deputy, members of the National Assembly, members of the state houses of assembly, local government chairmen, and their executive members or councillors. Because you go down to the local government, you find that even councillors have PA, SA, and all of that. So once a councillor makes you SA and you want to run for councillor too in your ward, you have to resign.
Well, interestingly, Mr. Onu,
So
that's a definition.
anybody who is appointed by a political, an elected official is a political appointee.
You know, incidentally...
Switch gears now to another topic. Let me ask you quickly,
Go ahead,
sorry, Kayode, whether you agree with the president's concerns. He talked about this provision has introduced some qualification or disenfranchises those. I'm trying to find the exact words he used now. I think it was in part 7 of the speech which he gave. He says Section 8412 constitutes a disenfranchisement of 7 political office holders from voting or being voted for at conventions or congresses of any political party for the nomination of candidates for any election in cases where it holds earlier than 30 days to the national election. He goes on to read what the section says, and it says this provision has introduced qualification and disqualification criteria that ultra-virus the Constitution by way of importing blanket restriction and disqualification to 7 political office holders, of which they are constitutionally accorded protection. And he says the practical application of Section 8412 will, if assented to by operation of law, subject 7 political officers to inhibitions and restrictions referred to under Section 40 and 42 of the 1999 Constitution. And he goes on to explain what he means. He says, you're placing a bigger burden on them than the Constitution itself places already on political office holders. Do you agree with that?
I do not agree with that. The president has made himself a judge in this matter. Like I said, if anyone feels his right has been infringed, the person should approach the court for interpretation of that section. Mm-hmm. Now, there is nothing disqualifying anybody in Section 8412. What you may call it is that there is a condition precedent.
Okay.
There's a condition precedent for participating in party congresses and by political appointees.
So you didn't agree with his reading and his interpretation of that?
I do not agree. Now, if you're appointed into public office, it is intended that you serve the people, not go there and be an extension of a political party.
Okay. Let's take a break at this point, and we'll come back and switch gears to the ruling that came out from Ebonyi yesterday. Please stay with us.
Abakaliki, the Ebonyi state capital, comes alive as thousands of APC supporters troop out in their numbers to show support for the Ebonyi state governor David Umahi following Tuesday's Abuja High Court judgment removing him and his deputy from office. The solidarity match at the popular Udensi roundabout in the state capital brings together party faithful from across the state. The Deputy Governor, Kelechi Igwe, addresses the crowd, restating the people's support for the Governor Umahi-led administration.
They consider the announcement some of them had yesterday as a travesty, which must be corrected. To me that this is a distraction that should just be ignored. That by your nature and your person, they know you will not be interested in responding to what is happening, that they have come to give you assurance. That comrade come shine, as your subjects, they are with you. Comrade come shine, morning, afternoon, and night.
Addressing his supporters, Governor Umahi urges them to remain peaceful, warning the opposition PDP against any unlawful activity while expressing confidence in the Nigerian judiciary.
This is another level. Do not be angry about the judgment. Say thank you to PDP. It is a joke that has been carried very far. And today we will say to PDP in Ebonyi State, enough is enough. Enough is enough. Anybody that goes against the law of Ebonyi State, we get it very hot from today. I'm just here to say two things to you. One is to be very peaceful. Number two is to assure you that we have still very serious confidence in the judiciary.
With the governor and his deputy approaching the appeal court with the aim of reversing the judgment of the Federal High Court, the coming days promise a display of legal fireworks by parties in the case.
Well, we're still on the matter of the Electoral Act, which the president had asked the members of the National Assembly to re-amend. It didn't come back amended. And we're also taking on the issue in Ebonyi State, where a federal high court here in Abuja sacked the governor of Ebonyi based on Section 221 of the Constitution. Well, he's now filed an appeal. That was the rally which held in the state yesterday. His supporters, showing their displeasure over what was happening, and he reassuring the supporters. We still have with us here in our studios Mr. Silas Ono, who is a legal practitioner. He happens also to be from Ebonyi State, and Mr. Dauda Arioshu, who is an associate professor, Faculty of Law, University of Ilorin, joining us via Zoom. Some people will say it was like a bolt out of the blues. Mr. Arioshu, I do not know what you made of that judgment which came from Justice Ian Ekwo, nullifying, it would seem, the votes cast, or will I say, not nullifying, saying that the PDP owns the votes and as such retains the votes, and as such when the governor was moving or defecting to the APC, he could not have gone as governor because that position rightfully belongs to the PDP. What was your reading of that?
Well, thank you very much. You see, although the case is still subsidized, because I learned that Umahi has appealed the judgment, but we can still pass our comments and analyze the judgment and the implications of the judgment. Well, as far as the court is concerned, judgment has been rendered, and any aggrieved party can go on appeal, which I believe Umahi has done. But looking critically to the judgment and effects, there are, in law, there's what we call precedent, legal precedents. And when there are precedents in respect of a particular matter, the precedents must be followed. I think similar issues have arisen in the past. And we know what the Supreme Court said in respect of the similar issues that has arisen even before the Supreme Court. When, yes, it is true that people contest on the basis of a political party. And it is the political party that sponsors you. But at the end of the day, who was declared by INEC? It's not the political party. It's not the political party, but the candidates at the election. So if His Lordship has heard that to the effect that it is the political party that sponsored the ex-governor, and that he ceases to be in office because of his defection, he and his deputy and the other members of the State House of Assembly. But the issue is, does the court has that power Yes, we know the case of Rotimi Amechi, but that position of the court has been overruled, and I think the present position now is that electors, voters voted for the candidates, because it's the candidate that will be declared as the winner of the election and not the political party. But since it's a judgment of the court, I don't think what we learned that the ex-governor did, or what he uttered to the judge, is appropriate. It's not appropriate at all. Yes, he knows the property, and that's what he has done. I learned that he has been apologizing but what he has done, he has done it well. No, the judges are human beings, and well, of course, they are prone. They can make their judgment, and it's not that their judgment is the final. So he has the right to appeal. So he has done. That's what he's supposed to do. But honestly, it is not the political party that was declared as the winner of the election, but Umahi. So, I'm sorry. So, at any rate, if it is the candidate that was declared, and you know, there is a freedom of association. If you have gone through the case, like I said, you have a similar issue that has arisen before the Supreme Court. The case of Atiku Abubakar, it's handy, and the Supreme Court said that no, you have right to freedom of association. You can defect. It doesn't mean that anything is wrong about your defection. If you defect from one political party to another political party, it doesn't mean that you have lost whatever benefits you have gained from that political party that has taken you to another political party. No, you work for it and you earned it. You, the electors voted, even though it is the political party that sponsored you. But that doesn't mean that it is the political party that was declared as the winner of the election. It is the candidate himself that was declared. So if it is the candidate that was declared, and he has the right, to leave that political party to another political party, which he has done. He has left PDP for APC. I has the right to do that.
If you can hear me, Mr. Ariosu, let me come in here, because we just came off the back of a conversation we had about, political appointees or office holders resigning before they either vie for an election or votes in party election, that is. And I think, this is not constitutional, and I think you agree that it's not quite provided for. That's why, in fact, the president thinks it's unconstitutional, let me just say, to stop them from doing that. But essentially, this was meant to cure an ill, as it were, eating your cake and having it, and some of the ills we have seen, essentially. So this was more like a moral thing, putting that in the Electoral Act. So we came off the back of our conversation onto this one, and it's been said here and there that the law is not quite clear as to what happens to a governor, a deputy, and the rest when they move to another party. But the section of the Constitution that the judge relied on, 221, that says, no association other than a political party shall canvass for votes for any candidate at any election or contribute to the funds of any political party or to the election expenses of any candidate at an election. And the thinking is, if you canvass for something, then you can only be the one to get that thing, as it were, and have the right to it. And that's the thinking, as it were. You ask for something, so I ask you for something. You give me, and I have a right to say it is mine, not another person's, and since I asked for it. So adding the conversation we had about the moral issue around political appointees seeking office or wanting to vote and still holding that office, and then this section of the Constitution as well, would you still fault that judgment?
Yes, of course. Because if you look at that section as other sections of the law, they cannot really override the provision of Section 40 of the Constitution, which gives every citizen rights to freedom of association. So, despite those provisions, the provision of the fundamental human rights will have overriding effect on all those sections.
So do you agree then that
that
Section 8412 of the Electoral Act also overrides, or at least infringes on persons' constitutional right of freedom of association? Do you agree then? Because it's
yes,
almost
I
similar.
agree. I totally agree. And that's
Also,
what,
you support the president asking for an amendment then?
Yeah. It's not that, like I said earlier, that of course the president can ask for an amendment, as long as the proper procedure is followed. And that's what I was saying, that yes, the provision is there, yes, until it is amended, it becomes the law. But the truth of the matter is that that provision will still be challenged in court because it will violate the provision of the Constitution as to right to freedom of association. And I think that is why the president is now asking for amendment. But like I said earlier, that why can't you allow the law to take effect? Let's see how practicable it is. And if there is any agreement, you can go to court and ask for striking down of a particular provision. And of course, the provision of that law violates and contravenes the provision of the Constitution. And to the essence of that inconsistency, it is null and void.
Okay. Well, let me ask Mr. Ono this on the same issue. I know it's a little dicey, when one looks at some of these issues sometimes. But look at this against the backdrop of the election that held at the FCT where you are recently, where a political party won, but there was no one to give the votes to on behalf of the political party. There was no one to return as a candidate or as winner of the election, even though the political party won. It would seem like this provision, this judgment, raises an issue that has been raised severally. And as you mentioned, there have been precedents. So in a case where a party wins and there is no one to return, and now someone defects from a party into another party, I don't know. It's a conundrum or an irony, if you like, or isn't it?
Well, my brother, the hypothetical scenario you painted now is an impossible one. When it happens, I'm sure it will certainly create a shock. But on the issue that we're discussing, there is a moral and legal issue about defection. And the judgment of the Federal High Court regarding Ebonyi State has established one thing, if nothing, that Nigerians don't want their elected officials jumping from one party to the other, because a lot of people welcomed that decision. So as a member of PDP, I am part of the plaintiff. So I would say that we have won already a moral victory, even if the legal aspect of it is still before the court. So I would not be making comments as a party in this litigation that will be considered prejudicial to it. But one thing I'd like to say is that we seem to have forgotten that this judgment was not just about the governor. There is also an important judgment about the members of the House of Assembly in Ebonyi State. And I do not think that the appeal and the application for stay that was filed yesterday included the State House of Assembly members who have been vacated. So I am free to talk about their case, the House of Assembly members.
What should happen in that instance right now?
Now, I'm going to also be calling on the National Assembly as they make this constitution amendment to also try and resolve this unnecessary controversy by bringing into the Constitution provisions like what we have in Section 68 1G and 109 1G of the Constitution, which clearly states that when a member of the National Assembly or State House of Assembly moves to another party other than that party in which he was elected, he shall vacate his seat. That one is clear. So they should do that for president, vice president, governor, and deputy governor, so that the issue will be put to rest once and for all. Whatever happens at the Court of Appeal and Supreme Court, I think the National Assembly ought to consider that, because it will make Nigerians happy, right? Now, for the Ebonyi State House of Assembly, the judgment is effective that they have vacated their seat. The Constitution is clear on that. So you find that it's not a matter of controversy.
So what should happen to their seats
They are not members as it is right now. Mm-hmm. They are not members as it is right now. This decision, mind you, is a declaratory judgment. It's not an election petition matter, for which there is absolute jurisdiction to challenge the defection of the House of Assembly members. And once the court declares that their seat is vacant, they must comply and then appeal from outside. So as it is now, the 8 members in the Ebonyi State House of Assembly have a right to elect among themselves new leadership. I say 8 members because there were 16 who started attending APC activities, carrying APC flag, carrying broom in Ebonyi State. One of them recently came and said, I have never cross-carpeted on the floor of the House, so I'm still a member of PDP. That is not a requirement in the Constitution. The Constitution did not say you should cross-carpet on the floor of the House. All it said is that being elected as a member of a party, you are no longer the member of that party. You vacate your seat. So how do we say you're no longer a member of a party? The moment we see you fraternizing with another party, carrying their banner, carrying their flag, you are no longer a member of our party.
Well, some people will say you have to actually have a formal defection.
There is nothing like that in the Constitution. The moment you identify with another party, you are no longer a member of the party that elected you. So if you want to become a member of the party that elected you, you have to come back and identify. But based on the Constitution, you ought to have vacated that seat.
Okay.
And then if you're coming back to your party, you have to go and contest election again to come back. So Ebonyi State House of Assembly, as it stands now, only have 8 members. And those members can elect new leadership among themselves. This matter is not controversial at all. You can see that all the lawyers who have been speaking for or against the decision of the Federal High Court have actually not gone into this issue because it is settled.
Okay. Well, we'll see whether that's the last word we'll hear on that particular matter, but we certainly know that the governor of Ebonyi has now appealed the judgment of Justice Ian Gekwo, and it will be left to see how the Court of Appeal decides. So we have to thank you, gentlemen, for coming on the program this morning. Thank our guest, Mr. Dauda Arioshu, who's an associate professor, Faculty of Law in the University of Ilorin. He joined us via Zoom from Ilorin in Kwara State. Thank you so much for coming on. And Mr. Silas Onu, who is also a legal practitioner and a member of the People's Democratic Party. Thank you also for coming on the program this morning.
Thank you, Margaret.
Well, we'll take a break now and we'll be back to talk about the security situation in the country. Please stay with us.